Employers are no strangers to legal change, but the Employment Rights Act of 2025 is different in scale and in timing. Some of these changes are already in force, and others are coming fast. The businesses that are best placed to respond aren't waiting for something to go wrong, they're training their managers now. Today, we're looking at what's actually changed, where the exposure sits, and how structured e-learning is the most effective way to manage it. I'm joined by Gill McAteer, employment law expert at Citation, who works with businesses across the UK every day on exactly these challenges. Welcome, Gill. It is great to have you here.
It's lovely to be here.
Thank you so much. So if we start with the big picture, for any employer who hasn't had a chance to dig into the detail of what's happening and what's happened, what's the scale of what's changed with the Employment Rights Act?
Well, the scale is absolutely enormous. It has been billed as a once-in-a-generation agenda for change, and I think that's certainly true. And I think what's very challenging for businesses, most of these changes are going to the very core of how they manage people within their business. And so therefore, it's not just a question of understanding what's changing, but actually what changes do they need to make to their operational people management as a result.
And that would be why we're talking about a training response as well to that change.
Yes, I mean, certainly. Most employers are now starting to realise that this is not about tweaking policies. This is about complete core changes to how you manage people, and managers are the essential element of that.
Okay, so what changes are live now?
Probably the biggest change for businesses has been SSP changes, because that means that employees are now entitled to SSP from their first day of sickness absence. Previously, the first 3 days were unpaid. So obviously that's going to have not just a big financial cost to businesses, but it's also going to put a lot of pressure on absence levels, which already was a very, very very challenging issue for employers to deal with.
And then beyond that, what's still to come?
Well, there's 28 changes in total.
Let's list them all one by one.
How long do we have? So 28 changes. 8 have come in already. We have about another 9 coming in October, and the remainder are coming in 2027. And I think if we look ahead to October, the big changes are going to be changes to the rules relating to harassment, with more onerous obligations for employers, a doubling in the length of time that employees have to bring an employment tribunal claim. And then in 2027, we begin to see some of the most fundamental changes, such as changes to the right to bring an unfair dismissal claim, and changes to 0 hours contracts and how you manage variable hours workers.
Okay, well, let's see if we can cover all of those off today. What are you hearing from employers about the changes that have already come into action?
Well, I think there's a great deal of confusion, because obviously with this extent of change, they're confused about, first of all, what is coming in, and more importantly, when is it coming in? Because there's a very tight timetable that the government has issued on when these changes are coming in, and it can be very difficult for employers to get their head around that. But then on top of that, they've got to think about, well, how do my policies need to change? But then, more importantly, what do I do on a day-to-day basis? What do my managers do on a day-to-day basis that needs to change so that we can navigate this successfully?
And trying to make that work alongside everything that you've got going on.
Oh, yes.
Anyway.
Absolutely.
I can only imagine.
Impossible.
I think there's a perception that employment law is usually just an HR problem and not really a training problem. It sounds like it might be quite dangerous at the moment.
Yes, I would say that was always a dangerous assumption. In my experience, and I've been advising employers for 30 years, by the time HR gets involved, you've already got a problem. What you really want to do is to stop problems arising in the first place. And that means training your managers to know how to handle difficult situations, to know how to implement policies and to do it consistently. So if you have really invest in training your managers, you can then ensure that, 90% of problems don't arise in the first place.
And I suppose to your point before, when we're talking about trying to make that work in the day-to-day, you're probably saving yourself a bunch of time anyway. training them as opposed to trying to do it.
Absolutely. Investing. Managers have so many hats to wear these days. I do feel very, very sorry for people in the role of manager because there's always something new coming out saying, well, looking after employees' mental health, managing performance, improving retention, improving employee engagement. They all rest with the actions of your managers. And that's why you really need to invest in helping them achieve those things.
So we mentioned SSP previously, haven't actually highlighted the fact we're talking about statutory sick pay.
Yeah.
So that's starting on day one by law now. What does that mean for a manager that's getting a sickness phone call on a Monday morning?
Well, I think for businesses generally, it's first of all important to recognise that this is likely to put a lot of pressure on their absence levels, which is already a challenge for employers. And therefore, there will be more onus on managers to be managing this more robustly in future. But equally, they don't want to overreact and perhaps create risk by dealing with people inconsistently. So it's first of all ensuring they know what information are they supposed to be gathering, how they monitor their team's sickness absence levels, and how they should be reacting when they think there's an issue. And it's also an opportunity from that very first call. If it goes well, it can really help support an early return of an employee. But equally, if they handle it badly, that can create conflict and actually might extend an absence.
And I suppose when we talk about the training side of things, I suppose that having that training in place would give a business an opportunity to have kind of a documented trail in place.
Yes, and that's essential. One of the biggest issues in tackling sickness absence and managing it effectively is the fact that managers often feel concerned about talking about health issues. So it doesn't get managed properly, and then that can create further problems down the line. So actually training can help give them the confidence of knowing how they can talk about those conversations supportively, and importantly, knowing how to deal with situations and problems when they arise. When is the point that they can escalate to taking, for example, potential disciplinary action?
Do you think it's a byproduct of being English that we don't like to talk about the health issues?
I think it is. I think, well, actually, in a report last year, they found that there was actually fear on both sides. Employees don't like to talk about health issues because they're concerned that they may face discrimination at work, or they won't be seen in the same way. And managers are worried that they'll upset people. And so the report was saying that at a time when actually it's in the business interest for communication to go well, people are very distant, and actually that can only make sickness absence levels worse. But equally, managers have got good reason to be concerned about making a mess of it, because that report also showed that it's unbelievable, but sickness absence costs UK employers £85 billion a year.
With a B.
Yes. And 10 million of that is sick pay costs, but 10 billion and 7 billion of that is actually the costs arising from conflict because it's been handled badly.
Really?
Yes. So it's, there is good reason for managers to be concerned about that, but that's nothing that can't be addressed by good training.
So for the ignorant like me, when you say managed badly, is that tribunals, that kind of thing, when conflict?
Yes, absolutely. It will be either not having an early conversation and just leaving it until frustration levels grow, and then they perhaps overreact, or treating people inconsistently. So the big areas of risks of claim here are discrimination claims, especially disability discrimination, and also constructive unfair dismissal, or indeed unfair dismissal.
That's crazy that it's 70 to 10.
Yes. Yeah.
Okay. Well, I should do my training. You also mentioned October, next date in the diary. Can you explain what employers will be responsible for under the third party harassment duty, and what counts as a third party?
Yes, so this is going to be a massive change for employers. In fact, we had third-party harassment when the Equality Act was first introduced, but it was abandoned after a couple of years because it caused so many problems. So this essentially is extending obligations to employers to make sure they take all reasonable steps to prevent their employees being harassed by a third party. And a third party is anyone who doesn't work for them. So
Okay.
it could be their customers or your suppliers, anyone who your employees interact with.
Could that be outside of the workplace as well then?
Oh,
Could it be-
yes. Yeah, well, for example, if you're sending your employees onto a client's site,
Right.
or if they are, working in a public area, yes, if the very nature of it, these are situations which are beyond the employer's direct control.
Yeah.
So it's knowing what you can do to make sure you satisfy that all-important, all reasonable steps test.
Okay. And does it apply to every business or is it just specific sectors?
Every business. So, for example, you may think, well, if you've got an office business, there's no risk, but you'll have visitors coming into your office.
Mm-hmm.
You will have your employees maybe going to events or conferences or networking events. It really is impossible to almost have a workforce that never comes into contact with the public.
Yeah. All I can think of now is charities and them having representatives on the
Yes.
street.
Absolutely.
How do you account for that?
Well, and I think this is where that's $1 million question really, is what can you do when so much is out of your control?
Yeah.
And there's a lot of things that you can do. You think about where interactions happen and what steps you can show to say that you have got, you have signposted it and tried to protect employees. But the key thing really is, again, training the employees to know that what is harassment, how they can recognize it, and who to report it to. Because if you're training your employees about what is acceptable and it's showing that your door is open if they've got any
Right,
concerns
okay.
at all,
Yeah.
that goes a long way.
I think for just to talk about the courses that we produce for a moment, the sexual harassment awareness course that we produced was always in top 5, top 10
Yes.
most used, but it's shot right up to the top over the last year or so.
Yes.
So it seems like a lot of employers are taking note of this and are trying to make their workforce as aware as possible of what isn't harassment and that sort of thing. Also, our bullying and harassment course has seen a big uptake as well. I suppose those two elements are kind of key to what we're talking about here.
They're absolutely key. And I think the good thing is, I think that training is actually split between employees and managers.
Right.
So training, when you're looking at showing that, I mean, the danger with this area of law is that you as an employer can have a policy saying these things must never happen. And then if you find out that they have happened, unfortunately, you'll be liable for it unless you can show you've taken all reasonable steps.
We really did try.
Exactly.
Right.
So having the right policy is only the start. Training is a critical foundational part of establishing that. And then, but it also informs the third part, which is also that managers are dealing with it effectively. So if you can carry out, you've got all the right policies, you can train everyone, but if your managers are not actively managing these situations appropriately when they arise, you will still be liable. And that's why it's so helpful to have separate managers courses.
Yeah.
So you're training them on how to deal with the situations when they arise.
And I suppose that also comes back to what we were talking before a little bit about with the documenting these kind of things, keeping that paper trail.
Absolutely. The number of times, unfortunately, over my career that I've seen situations where things have been dealt with. In fact, employers have been genuinely very upset that things have happened and they've just jumped on it straight away, had a conversation and sorted it out. But then further down the line, it's happened again and they don't have any paper trail of what they've happened. And then they've faced the allegation in a tribunal. Well, I complained about this before and nothing happened and now it's happened again. So, yes, I'm an employment solicitor, so you could never document too much in my book.
Yeah. So, yeah, good intentions, great.
Yeah.
But if you're not backing that up with doing the right process.
Absolutely.
Mm-hmm. So one of the elements of it that I've heard about is the 6-month probation policy and the changes there. If you could maybe touch upon that a little bit. I believe that's January. That's coming into force.
Yes, that's from the 1st of January. And this is probably the most transformational change in the Employment Rights Act, because for years we have always had a significant service requirement before someone can bring a claim for unfair dismissal. For the last few years, it's been 2 years service, which is quite a relaxed period because it does encourage employers to, take more risks in employing people, thinking that I've got 2 years to get rid of them before they can bring it on for dismissal.
Yep.
And, even then, very often, that's a date that gets diarised and they only really start to think about it, a couple of weeks beforehand. That's changing because the service requirement you need to bring an unfair dismissal will change from the 1st of January to 6 months. Now, most businesses have a probation period of 6 months. And indeed, I would say that needs to be reviewed now because, if 6 months and then someone goes off sick, they're going to tip over that 6-month period. So the whole approach that employers have to what the probation period should be, how they recruit, how they induct people, how they manage during probation, absolutely needs to be looked at, and now is the time to do it if it hasn't been done already.
Yeah, that was going to be my follow-up question. If you are hiring people now, I can imagine you think, oh, well, it's not till next year. It's not till January next year.
Yes.
I've got more than 6 months probation. But that is something they should be considering now.
Absolutely, because it used to be that anyone you took on, you had that 2-year period. If you take someone on now, and you don't deal with any issues before the 1st of January, all they'll need to show from the 1st of January is they've got 6 months service. So, and one of the dangers can be is it's not just simply a question of saying, right, well, as long as I do not go past that 6-month point, then it will be okay. Because you have a whole host of reasons why people can bring a claim without any service requirement. So people who want to bring a claim for protected characteristics, or because they say they've raised health and safety issues or whistleblowing issues. So if you suddenly dismiss someone out of the blue without any documented reason why, you face the potential of a claim.
Which brings me on to my next question then. We're talking about training quite a lot. How can a consistent training program help with issues like that?
Well, consistency in managing these situations is absolutely fundamental because where you have inconsistency is where it gives rise to allegations of unfairness and discrimination. And discrimination claims and unfair dismissal claims are the 2 biggest claims that employers, generally face. So working out as your business what the changes mean for your policies, and then training your managers how to implement those, what they need to change about, how they're recruiting people for their team, how they need to structure inductions, how they manage in those early months. The government has said that absolutely the key to this new process is about setting expectations from the start. So, for example, if you take someone on, it's brilliant if you find someone who ticks every box, but recruitment is difficult and sometimes you have to make compromises.
Sure.
And if you're bringing people on who perhaps had some obvious areas during the recruitment process which weren't quite up to the standard you were looking for, have that conversation documented, have a plan on how you're going to help them improve in those areas. But of course, it's all about the documentation. It's all about the consistency. It's all about not putting it off and say, I'll do it next week. Because I know a lot of employers who are actually reducing the probation period to 4 months, and that flies by in no time at all. So you absolutely need to be on the ball with this from day one.
In terms of the training that we produce, I know that we've tried to put an emphasis on the recruitment side of things and the induction and performance management, which I suppose is really what you're getting at here. Is there anything else that you think people should be being mindful of when it comes to trying to fill out that, getting a full picture of training, I guess?
No, I think that's really covering it. If you're really doing your best to make your recruitment process as strong as possible, you're giving people the tools to get off to the best possible start, and then you are dealing with performance issues at an early stage and in a supportive stage. You really are giving yourself all the tools you need to successfully navigate this new requirement.
And even with that, if you're reaching the 6 or 4 month probation period and you've got nothing documented, presumably that's the real danger zone.
That is the real danger zone, because then if, first of all, if it trips over the 6 months, so it may be that you have invited someone into a probation review. Probation reviews, in my experience, they very rarely take employees completely by surprise. It's very rare that someone is going into probation review thinking that this is just brilliant and, they're going to get a gold star.
And then they're being let go.
Yeah, exactly.
Yeah.
They do sense. So it's incredibly common for us to find that managers face situations where the employee then goes off sick. Now, when you have got that 6-month deadline, what are the chances you'll be able to deal with the situation before that 6-month trigger is passed? And if you try to do it before then, and you've got no documentation, the danger is they may turn up and say, well, actually, it was because I raised this health and safety issue, or it was because I asked for carer's leave, or it was because of my age, or it was because of this health condition I have. And then it's your word against theirs without the documentation. And that's why it's so important that managers are trained to understand the importance of documenting things. It can seem like just some unnecessary admin, but in tribunal, contemporaneous documentation is better than any witness you're ever going to have.
Right. Sounds good. I will definitely make notes moving forwards. So talking about tribunals, I know it's going to differ from case to case, but broadly speaking, would you be able to assign a number to legal fees, management time, if there's a settlement potentially?
You are looking at solicitors' costs from between £250 to £450 an hour.
I'm going to say a day.
For legal. I know, an hour.
Yeah.
And you've got to take into account as well the fact that, I would say up until recently, the average number of days in a final hearing was around about 3 days. Our average number of days is a 5-day hearing.
Right.
And forget all the preparation to think of the cost there. So even a straightforward claim can easily cost upwards of £25,000. And that's quite apart from the disruption, the effect it has on the morale within the business, the fact that every moment you're spending on that case is time away that you are taken away from your business. And, the sheer fact that these things drag on for years now. We are already seeing cases listed for 2029.
Really?
Yes.
Wow.
So it's a huge diversion and distraction for business owners.
How does it get pushed out that far?
Just because the cases lists are so extreme. I think in the last reported figures, cases in the last quarter, tribunal case in the last quarter of 25, were I think over 50% higher than the last quarter in 2024. And this is before we have seen the impact of the Employment Rights Act.
Right, and we're going into a place where that's going from 2 years to 6 months.
Yes.
Good time to be a solicitor.
Yes.
If you could name a single factor that really separates a business or an employer that is well prepared for something like an employment tribunal versus someone that isn't, what would that be?
Well, I think it starts long before you actually get to your employment tribunal, because it's really all about process. To have fair processes which your managers are trained on, they apply them and they apply them consistently, and they're documented.
Mm.
That will vastly reduce your risks of ever facing a tribunal claim. It won't remove it, because anyone can bring a claim as long as they have got the service, depending on that particular claim. But should you face a claim, and obviously there would be a reduced risk there, you will stand a much, much higher chance of actually winning that claim.
Mm-hmm. Something that some of our sales team talk about is people coming back to us saying, I guess essentially it's what's the return on investment on training. But when you're talking about potentially £25,000 plus on a single tribunal case, it sounds like obviously this sounds like a marketing piece now, doesn't it? But that sounds like a very good return on investment to be able to be prepared, have everything in place, have your policies, have your plan of action there off the back of the training that you've taken.
Yes, and that's only comparing it with the potential of one employment tribunal claim. But I would say think of all the other benefits you're getting, even if you don't face that claim, because actually being part in a well-run business where you can see that performance issues, conduct issues, sickness absence issues are being dealt with consistently and fairly has a massive impact about how people feel about, their role in that organization.
Mm-hmm. Great, yeah. I guess if I was listening to this now and I was a training manager or an HR, someone representing HR for a business, and I'm thinking I should probably do something about this, what would you suggest?
Well, I would suggest look at those key areas that are most affected by the Employment Rights Act changes. We're talking about how you manage sickness absence. We're talking about recruitment, induction, performance management. We're looking at how you protect your employees for harassment with a view to third-party harassment as well. And think of, first of all, what processes do you need to change, and how you're going to train your managers on making sure that they manage those changes consistently.
So I guess as a final thought, the changes seem to be very far-reaching and, as you say, kind of generational. What do you think it means for UK businesses when they're thinking about training moving forward?
These changes have been very resisted by employers, and I can understand why that is the case, because it's almost like a painful growing pains that they're being forced to go through. Because actually, these changes should, if they're navigated successfully and adopted in your business and reflected in your processes, should mean that you have stronger businesses, because performance issues will be managed more effectively. You will be recruiting better people. You will be managing sickness absence more effectively. But you need to train managers to make sure that those things are done in practice. And actually, your managers bring not just your processes, but the culture of your business to life. And I would say investing in them is one of the best things that you can do through training in ensuring that you are building a stronger business.
So today we've covered what's changed under the Employment Rights Act 2025 and what's still coming, the SSP changes now in force and what that means for managers, how to protect your business as the qualifying period for unfair dismissal shortens, what the third-party harassment duty means in practice, and the real cost of untrained managers and the potential return on investment for getting that right. Thank you very much, Gill, for coming in today and sharing all of your expertise with us. And thank you for listening. If you found today's episode useful, please share it with a colleague who manages people. This really does affect every business. And if you'd like to explore the full range of ERA-linked courses, you can have a look at iHasco.co.uk. Thank you very much.